Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, everyone. Welcome to our Curious Amalgam, a podcast from the American Bar Association Antitrust Law section. My name is Lexi Michaud, and I'll be your co-host for today. Today's topic is, do I really need to file? HSR Avoidance and the Edwards-Genesis settlement. And joining me today is my co-host, Jeny Maier. Hi, Jeny. How are you?
Hey, Lexi, doing well.
Would you introduce our guest for the day?
Yep, absolutely. Today, we are joined by Evan Miller. Evan is a partner at Vinson and Elkins, and his practice focuses on antitrust and competition, in particular on merger review and HSR compliance, which is the topic of our conversation today. Evan's work covers merger reviews, investigations, HSR filings, litigation, in particular with an emphasis on the energy sector and AI sectors. One thing that is interesting about Evan is that he is the editor of the forthcoming new edition of the ABA's treatise on gun jumping and pre-merger coordination. So he is a wonderful guest for our topic here today. So we're really excited to have you here, Evan, to talk about HSR avoidance and the recent Edwards-Genesis settlement, which has been a really hot topic for practitioners in the M&A space, and we're looking forward to the conversation.
Thank you so much for having me.
Great. Thanks, Evan. So before we really get into the Edwards-Genesis settlement, we want to help our listeners level set. So can you, at a high level, tell us what it means when we talk as a legal matter for parties to a transaction to run afoul of the HSR Act, the anti-avoidance rules, as opposed to a deal that simply and legitimately falls below the filing thresholds that are in the HSR Act?
Yeah, absolutely. I think it's a great question to start with because I think that distinction matters a lot in practice, right? So the HSR Act requires parties to a transaction to file a pre-merger notification with the FTC and the DOJ and observe a 30-day waiting period when the deal exceeds a certain size of transaction and size of person threshold. That the thresholds are updated annually. Right now, the primary threshold for the transaction value is $133.9 million. When a transaction genuinely falls below those thresholds, there's nothing wrong with that, obviously. Parties have no obligation to file if they're below that threshold. And in fact, the HSR Act is not a voluntary filing system. Like, you have to kind of be above the threshold in order to file an HSR Act in the first place. So the FTC doesn't want you just to go in and file below the threshold. They want you to be above the threshold and file when it's appropriate to do so. So structuring a deal to achieve a legitimate business objective that happens to keep the value below the threshold is perfectly lawful. If the deal is just valued below the threshold, perfectly lawful. The law doesn't require the parties to maximize value in some way to get above the threshold or do anything like that. So where it crosses the line into avoidance is when the parties structure a transaction or a series of transactions with a specific purpose of keeping the reportable consideration below the HSR threshold, when the true economic value of what's being transferred between the parties is actually above that number, that 133.9 million now, or whatever it is when you're doing the deal. And the key there is the intent to avoid the HSR Act's pre-merger notification requirement, combined with an artificially engineered structure that misrepresents the real economics of the deal. And the FTC treats that, as it should, very differently from an organic deal that just happens to come below the threshold.
Right. So when the agencies encounter a deal that they think should have been filed, what are the tools that they use to address transactions of that kind? Can you talk a bit more about sort of the anti-avoidance rule in the HSR Act, which is, for those of us who are familiar with it, Section 801.90, and how it operates? And it's funny, I'm thinking about this because we actually previously released an episode on reverse acquihires where we touched a little bit on 801.90 of the HSR Act, but hopefully you can give us a bit more background today so that our listeners understand where we're coming from with this.
Yeah, certainly a hot topic, right, of questioning whether or not the agencies are going to start poking around and looking at these innovative kind of new deal structures, see if they're kind scheme to avoid the HSR Act filing requirement. But to get to your point, Section 80190 of the HSR rules, the anti-avoidance rule, it provides, and I'm going to quote a little bit from the language of the rule, it provides that any transaction or device entered into or employed for the purpose of avoiding the obligation to file is itself a violation of the act. And really what they're saying there is that they would disregard that structure, right? So they're going to disregard anything that's artificially designed to avoid an HSR filing. And once they disregard it, then you're automatically not in compliance with the HSR Act because you've closed the deal without filing and observing the waiting period. And so you're in non-compliance. So they kind of just disregard it and say, we're disregarding that structure. This was a reportable deal. You should have filed. You're in violation of the act. But the language itself is a fairly broad catch-all. And what it means really in practice is that the agencies can pursue parties who structure deals to circumvent the filing requirements, even if individual pieces of the deal viewed in isolation may not have triggered a filing obligation, because this often arises, and I think we'll talk about this more, in deals where there's multiple pieces of consideration or multiple parts of the transaction kind of going on at once. So in terms of how 80190 operates in practice, it requires agencies to establish that the transaction was structured with avoidance as the purpose and not just the byproduct of some other structuring rationale or legitimate reason. And that's often proven through internal documents, emails, board presentations, banker communications that show the parties were aware of the HSR threshold and really deliberately structured the deal to stay below it. So the agencies have really leaned into their investigative powers to get to these documents, right? Civil investigative demands, subpoenas, to unearth these deal documents that may disclose what the true purpose of the structuring might be. And one thing that I always find interesting is, and I get asked this by clients, is you might wonder how the FTC learns about these deals in the first place, right? Because they're not reported to the agency. Sometimes they're not public, but sometimes they are, right? So sometimes people will put out a press release and the FTC is just watching the industry and says, hey, that's interesting. I see this press release. The deal seems like it might be reportable. We don't have the HSR filing for it. So they will reach out to the parties and kind of ask why it wasn't filed. The agencies can also learn about a deal from a competitor who may call into the agency and say, hey, our competitors just merged and we're wondering why you didn't take any action. Customers might also make a call to the FTC if they have concerns about the deal and why it wasn't investigated. And then another one is a subsequent HSR filing, right? So if you have a series of acquisitions in a specific industry, you may make a later HSR filing that includes information about a prior acquisition that was not reported, and the agencies might look at that and say, wow, this is really, this roll-up or serial acquisition has really gotten pretty far down the road without us knowing about it. Why didn't we know about it? And they might start looking back at those prior transactions. And so once they see the evidence of that deliberate structuring, then they may start investigating it. And if they ultimately find you're not in compliance, to your point, what tools can they use to address this? They can start fining the parties up to $53,000 for every day that they're in non-compliance. And that can add up quickly, as we'll talk about in a little bit, I think, with respect to Edwards.
Well, Evan, you completely anticipated my question. Thank you for the great answer, because it is a really common question that you get from clients just on the how will they find out is an important question from at least our client's point of view. So maybe we'll turn and talk about the Edwards Genesis settlement. Lexi, do you want to give us an overview of what happened there?
Yeah, and Evan, in your response, you not only anticipated Jenny's question, but you definitely anticipated some of the questions we're going to get into on Edwards Genesis specifically. So at a very high level for our listeners, and I'm sure you'll give more detail, Evan, but we have Edward Life Sciences, a major medical device manufacturer, including heart valve products. To really simplify it, because I'm not going to pretend that I know much more than that when it comes to medical devices. In 2024, it agreed to buy JC Medical, a smaller company developing a device that's implanted to treat a type of heart valve disease, from JC Medical's parent company, Genesis MedTech. No HSR filings were made for the deal. Can you, Evan, walk us through how the deal was valued and structured, and talk a bit more about some of the things you alluded to, different transactions, how the agencies find out about transactions that should have been filed?
Yeah, absolutely. And so what I'm taking away from this is that I practice saying aortic regurgitation for nothing. Into the science. Okay. So you can just go straight into the HSR analysis. Yeah. So the deal was structured so that the upfront purchase price fell below the HSR threshold. And so at the time, the HSR threshold was, I believe, $119 million. I think that's what it was in the year that this was supposed to be filed, right? And so what they did is they said, okay, the upfront payment for the deal will be $115 million. And then there was some additional consideration that was separate from the upfront payment. So the deal also included a contingent payment component, which was like a milestone payment tied to regulatory approval of the medical device, commercialization of that device, that I think, looking back at the FTC complaint, was valued at $1.8 billion, or at least that's what the FTC alleged that it was valued at. And then in addition to that, so you can see, if you're doing the math at home, we're getting closer to the 119, right? And then on top of that, there was a separate $25 million investment by Edwards in Genesis that was kind of treated separately by the parties, but was ultimately viewed by the FTC as part of the consideration for the deal. And so when you add the 115 plus 1.8 plus 25, the total value of the deal pretty meaningfully exceeded the $119 million threshold at the time. And so the FTC's theory was that the parties deliberately structured the deal to front load less consideration and push more value into the contingent payments and this separate investment. And what's important also is that the HSR rules have specific guidance on how contingent payments and other payments like this need to be valued and included in the HSR and the HSR valuation. And so the FTC ultimately concluded that the parties got it wrong or deliberately ignored it, but ultimately tried to kind of break apart these pieces and treat them separately in a way that they shouldn't have, it for the purpose of getting the transaction value below the threshold.
So what I think is really notable about this particular matter, looking at the FTC's complaint, is they refer to some very blunt or direct internal communications among the parties, including an actual statement that says that the deal was structured to stay, quote, below the threshold, and that this was, quote, intentional. So can we sort of discern, based on those allegations in the complaint, the weight that the FTC gave to these internal documents as it built the case?
Yeah, for sure. I mean, these documents were central to the case, right? I think they're almost certainly the reason why the FTC actually brought an enforcement action in this case. I think there's some other reasons around the broader actual competitive analysis they were doing at the time, but I think it is a reason why they brought the enforcement case, pursued penalties, as opposed to just kind of closing the investigation, having the parties file, observe the waiting period, and then kind of move on. In an avoidance case, as we talked about earlier, intent is a key element in proving a Section 811 violation. The economic analysis and the deal structure itself is suggestive and directional, but not dispositive by any means. There has to be something more to show that the purpose of the structure was to evade antitrust, and what really locks in a case is this type of direct evidence. So we have an email or a memo like this that says, in substance, we structured this deal to come in below the HSR threshold, and that was intentional. That's about as direct as it gets. And Jeny, what's interesting about the email that you're referring to is that this was an email to Jeny, which was another competitor in the space that Edwards was positioning itself to buy after closing this acquisition of JC Medical. And I wrote down the quote that you just read because I thought that you were saying they even included an exclamation mark, right? It said below the threshold, exclamation mark, intentional, right? And so it really, and that was quoted in the complaint. The FTC really put it up front and center to say, there's no question. It eliminates the ability to argue anything about the structure being legitimate or for any other business reason than to avoid HSR review, plus the other factors that they were pursuing this secondary acquisition of Jeny, which we can talk about a little bit more. But stepping back and thinking about how we counsel clients, I always try to advise folks to be very careful about how they communicate about deal value and structure, not because there's anything wrong with analyzing the deal from that perspective. We all have to do that analysis to make sure that we know if the deal is reportable and what about the structure is making it reportable. But the real counseling point is that casual language, just using kind of the wrong terminology or just kind of casually throwing around, oh, it'd be great if we could avoid HSR, that could really be problematic down the line. And so you really want to avoid using that type of language.
One thing that you just alluded to, Evan, in the answer that you just gave is the existence of this second transaction, which is how the agency presumably learned about the first transaction and the lack of an HSR filing there. So for our audience here. So Edwards here closed the JC Medical deal, and then the next day agreed to acquire JC Medical's only alleged U.S. competitor. That was JenyValve that you just referred to. So how did the sequencing of events sort of build the FTC's case, particularly around the intent piece of the complaint?
Yeah, I think this was one of the most striking facts in this case, right? Because you have closing one acquisition and then you're signing another acquisition the next day in the same competitive space. That's not something that happens by accident, right? Especially when you're communicating with the second target about avoiding HSR with the first target, right? So the FTC used that timing to support its broader narrative that Edwards was systematically acquiring competitors in this space in a way to evade regulatory scrutiny. It really gave more weight to their purpose argument, right? That the purpose of the structuring of the JC Medical transaction was to avoid HSR scrutiny, to avoid delaying the acquisition of JenyValve, and to kind of further inviting scrutiny of their serial acquisitions in this space. And I think the other aspect of this is that the FTC, which makes sense, right? They looked at this and it just reinforced their own belief that there was something going on here, right? That there was some effort by Edwards in an attempt to evade regulatory scrutiny that signaled that they were aware and concerned about the competitive harm that could come from these transactions, and were aware that the FTC may have had substantive concerns about these transactions, which they ultimately did with JenyValve. And it also, just from a litigation perspective, it also gave the FTC the ability to tell a really compelling story and to really paint a good narrative about what was going on. And again, to kind of fill in the blanks on this, the intent and the purpose aspect of this. And it's much more compelling to a judge than more of a technical dispute about, if they didn't value the contingent payment the right way, or they didn't include this other aspect of consideration in their total, and they had a technical breach of the HSR Act. Like, this is a much more compelling and kind of grandiose narrative about wrongful evasion of the HSR Act.
How unusual do you think that this is? Certainly, as you've been saying, that this has been a sort of pretty striking set of facts as alleged by the FTC. Do you think it is actually unusual to see the agency pursuing avoidance in a circumstance where they've also prevailed on a merger challenge?
I think it's unusual in the sense it doesn't happen every day, or at least we're not aware of it happening every day. And I think the Edwards case, it's a good reminder to our clients. They need to think about their regulatory strategy like holistically, right? They need to think about it. They can't think about it in isolation, like each separate part in isolation, right? Eventually, these things all start to kind of come together, and there could be a pattern, or there could be a larger piece to this that the agencies want to investigate. I mean, agencies have recently been really interested in roll-up acquisitions, serial acquisitions, things like that. And they are taking a look at this holistically, and we'll start poking around. So it'll be interesting to see if this comes out, if similar types of fact patterns come out more now that the FTC has this experience with this Edwards case. But I think that this one was somewhat unusual. The FTC does poke around somewhat frequently on avoidance questions, right? And does ask clients if they kind of did the proper work to make sure the HSR filing was not necessary in a specific deal, but to have this staged, purposeful, intentional evasion of the HSR Act for purposes of setting up a second transaction in the same industry that the FTC then sued to block, and then kind of used it all holistically to paint this picture of an anti-competitive kind of serial acquisition strategy. I do think that is somewhat uncommon.
And I guess to dig in a little bit more on that, so the FTC also challenged Edwards' transaction with JenyValve, and the court in the JenyValve injunction case later pointed to JC Medical structuring and timing as relevant evidence of the competitive effects analysis as part of that analysis. How unusual is it to see that kind of structuring actually become a part of the court's analysis of an entirely different later transaction?
Yeah, I mean, it's a great question. Again, I think that this fact pattern is somewhat unique, but the concept of using an acquirer's prior conduct in the industry as evidence that they were pursuing some sort of anti-competitive acquisition strategy is nothing new, right? I mean, that's something that is used in antitrust litigation, it's used in merger litigation. And so I'm not surprised by that. And I think the FTC, that was, again, this was such a good narrative for them to use to support their argument that this was, on the HSR side, that it was a purposeful evasion, and that the purpose was part of this larger strategy to consolidate this specific product market, that it was a very compelling piece of evidence. And I was not surprised that they were using that affirmatively in court. I was not surprised that the judge cited to that as part of kind of the reasoning behind the anti-competitive effects analysis. I mean, it all makes perfect sense. And I think it's not something that a judge or the FCC could ignore or should ignore as part of their analysis. Like, it's definitely part of the picture. And it's why earlier I was talking about kind of thinking about your regulatory strategy as holistically. You need to start thinking about how all of these different things that you're doing paint the picture for you as a competitor, as an acquirer, whatever your position is in a specific market, because it all becomes relevant.
As you highlighted, Evan, this is certainly a very unusual case. And as our listeners may know, so JC Medical and Edwards and Genesis agreed to a settlement with the FTC for the alleged failure to file. And they agreed to pay a combined $12 million penalty, which is the largest that has been on record. And that was divided up between the two parties, with Edwards, the buyer, they're paying $10 million penalty, and Genesis, the target, paying $2 million. What's the sort of history of similar penalties in the past for failures to file, and how does this compare?
Yeah. So, I mean, I think, if I recall correctly, that, I mean, the last large one that comes to mind was Canon Toshiba. And that one, there was a $5 million penalty split evenly among the parties, so $2.5 million each. And the case similarly involved a structured transaction that the FTC concluded was designed to kind of evade the HSR filing. But I do think the jump from $5 million to $12 million is fairly significant, right? It's more than double the previous record. And I don't think that's a coincidence. I think that the FTC signaled very clearly that it intends to use its enforcement tools aggressively, including on procedural violations like HSR failures to file. And the penalty level, I think, is an attempt to also send a message that the cost of getting caught is increasing. And this may be intended to change kind of the cost benefit analysis that some business folks might do, right? If they're like, well, what's actually the real harm or likelihood of getting cost, and how will that affect us? And so when they're deciding on whether to structure a deal a certain way, or if they should just kind of ignore advice of counsel, which I'm sure we're all giving the best advice on, but like, they're choosing to ignore that, they may just say, well, what's ultimately the risk? Like, what is actually the harm? So I think the FTC wanted to send a message that, like, we are going to come after you if we find out about this. I do also think that, again, I think this case is somewhat unique, right? I think that the facts are very bad, and the FTC really wanted to make an example of this as like an example of a really kind of blatant HSR Act evasion. And so I think that's also why we saw the fee kind of jump up considerably from prior enforcement actions.
And why do you think the split was 10 million on the Edwards side and 2 million on the Genesis side? I was thinking back to Canon Toshiba. If you look back at that case, it was split evenly. So why here split it unevenly and pretty aggressively, 10 on 10 and 2?
Yeah, I think that it reflects the FTC's assessment that Edwards was really driving the structure and the decision not to file. Edwards was the acquirer. It had more bargaining power in setting the terms of the deal and kind of structuring the deal. The internal communications that were quoted reflect Edwards' perspectives and priorities, not so much Genesis. And so the FTC, I think, was really focused on Edwards as the person, or as a company that was driving the decision not to file and the ultimate valuation. And it was obviously, again, part of their larger strategy. So that all, I think, was considered by the FTC in allocating more of the fee to the buyer. And Genesis was a seller. They obviously agreed to the structure. And so that's why they ultimately were hit with a penalty, a smaller one, but still part of the penalty payment.
And in previous actions, the agency often, for failures to file, doesn't penalize the seller. What factors between the Toshiba case and this case sort of lead you to believe that what were the conditions that made it likely that the agency was going to pursue action against the seller?
Well, I think from my perspective, at least, I think this is an effort to indicate to the seller that they're part of this, right? Like they are a part of the deal analysis. They have an obligation to come to their own conclusion about whether or not an HSR filing is required. They have their own HSR filing obligation. They have to submit their form on the acquired side. And so there does seem to be, I don't know if we can say two is a trend, but there seems to be a trend to say that if you're part of structuring the deal, you're involved in negotiations, and you're ultimately part of the HSR analysis, you do bear some of the blame for the failure to file. In the Toshiba Canon case, I think there was more of a collective effort to structure that deal in a way that avoided HSR filing, which might explain the even split. Here, I think it was a lot more on the Edwards side, but the FTC did still recognize that the seller was involved in this process. And just from a deterrence perspective, I think it's probably a policy objective of the FTC to make sure that the seller has an incentive to be involved in this process and to check the buyer's math and to check the buyer's structure and to have skin in the game, so to speak, to make sure this doesn't happen kind of unilaterally.
To press on that a bit more, Evan, I think when you think about from the seller's perspective, you do often take a backseat when it comes to structuring the deal, and you might defer to the buyer a bit more than you otherwise would like to. How should counsel think about counseling a client in that context to make sure that they're involved in those discussions and to make sure that, like you said, they have skin in the game and there's some kind of involvement?
Yeah, no, it's tough, right? Because I think the default for the seller on the structure is often to be passive, and on the HSR analysis to be passive and to take kind of the buyer's word for the HSR analysis and the structure and valuation and so forth. And some aspects of the HSR rules actually say that we're kind of relying on the buyer's determination of value in some instances. It has to be a good faith determination, but we are relying on the buyer's determination of value in certain instances. So it's understandable, right? This is an understandable feeling of kind of relying. But counsel for the sellers should be really pushing to do an independent HSR analysis. That means reviewing the structure, reviewing the total consideration, aggregating upfront payments, milestone payments like contingency payments, earnouts, ancillary agreements, other investments like we saw in the Edwards case, supply agreements, IP licenses, anything that has value, making sure we have a total kind of accounting of what's being transferred that has value, and making sure that the aggregate does in fact sit below the HSR threshold. And if there is genuine ambiguity about whether filing is required, I think the seller should be kind of aggressive in stress testing that conclusion, pushing for a filing if you do think reasonably that you are above the threshold, or at a minimum, just making sure that there is nothing in the structure or in the history of kind of the deal process that would indicate that you're structuring the transaction to avoid, for the purpose of avoiding the HSR filing. So there are red flags to look out for, right? Like if the buyer is just like, it's pegged to this number that's just below the threshold, and there's no moving off that number, even though deal terms are fluctuating, like that might be a time where you start pushing a little bit harder on the deal team and the other parties, HSR counsel, to make sure that you all are aligned, that this is the proper analysis. And I think it's also helpful just to make clear that to the seller that there is liability on both sides, right? As we just discussed, like there could be fines levied on both sides of the transaction. The investigation costs obviously hit both sides of the transaction. That's nothing to sneeze at either. So it is a problem that you're not being a pain just for the sake of being a pain. Like this is something that you all need to do to protect both companies' financial interests.
A great point. So perhaps pivoting to looking forward, given the actions here with the FTC, Chairman Ferguson, in his public statement about the settlement, had a really pointed commentary that companies should not try to sneak deals through without the lawful FTC review, and that these companies should take notice. How would you characterize the agency's current posture towards HSR enforcement? And do you see this as a sort of meaningful shift in the agency's practice from the past looking forward?
Yeah, I mean, I think there has been a meaningful shift. I don't know if it's solely this case, but there has been kind of a trend towards the FTC taking an aggressive look at procedural violations, right? Whether it's failures to file, withholding item 4 documents from your HSR filing, doing some of the kind of other, taking more aggressive interpretations of HSR rules and things like that the FTC has argued are kind of impeding their ability to review these merger filings. So I don't think it's new, but I think this is an exclamation on the trajectory of this trend, which is that the FTC is aggressively using its tools to go after technical violations of the HSR Act, seeking record-setting penalty on gun jumping, on failures to file, like all these kind of more technical HSR Act violations. They are really going after them hard and seeking penalties that will, in their eyes, hopefully deter future violations. So I think for a long time, failure to file cases were rare. This is obviously a very recent one, and the Chair Ferguson's statement about it and kind of enthusiasm about these types of enforcement actions certainly to me indicate that it's something that they're looking at closely and that they'll continue to pursue. And again, this is all part of signaling to the business community, to the deal teams, to the HSR lawyers like us, that they are looking at this, and I think that they're hoping that that will have a kind of follow-on deterrent effect, and we will continue to advise our clients properly, and they will continue to listen, and we will avoid these types of pitfalls.
So perhaps just to wrap things up, what do you think, and you've shared a lot of great helpful guidance for clients and for practitioners who are working with clients to deals, what sort of takeaways or best practices in light of this event should deal teams and their HSR counsel have in mind and going forward on making sure that they are being appropriately compliant?
Yeah. So I touched on a few of these already, as you mentioned, but I think the main takeaway is that when you have a deal where the value is really close to that threshold, you have to take a really hard look, right? Oftentimes clients will sometimes just kind of summarily say like, oh, we're just under, it's fine. Like you really need to dig into that and understand what the valuation is, because the clients may not be appreciating the fact that you need to aggregate all this consideration. So I think the first point is just dig in when you're really close to the threshold. The second point, kind of relatedly, is to make sure you're aggregating all the consideration. Don't just look at the upfront purchase price. Don't just take the word of the corporate team or the client that this is the value, because there are peculiar HSR valuation things that you need to be aware of, and they may not be considering that. And so you need to make sure you're considering the earnouts and the contingency payments and the side investments or whatever is part of your deal. And you need to make sure that you're valuing them the way that the HSR rules require you to. Right. The idea is that you need to watch your internal communications. I think I mentioned this earlier, but try to avoid being casual with structuring and valuation language around potentially avoiding the HSR filing. You just don't want any of that in writing. Not because, again, obviously you're trying to obscure evidence from the FTC, but because that's almost never really what's going on, right? Like that's something that is said casually, but the larger point is that there's structuring for tax reasons or for some other reason. And then the byproduct of that is that you avoid an HSR filing, and that's perfectly fine. But you just want to make sure that you're not creating evidence that could be misinterpreted or it would have to be explained away that could burn time and money in an investigation phase with the FTC. And then to that point, the final point I think is just like when in doubt, if you think you are above the threshold or there's a reasonable basis for you to be above the threshold, the cost of the filing fee, the 30-day waiting period is going to be less than the cost and the time of an investigation, of an enforcement action. And so if you're close or you're below, but on a kind of a gray judgment call, think very carefully about whether it makes sense to file or whether it makes sense to go into the P&O and ask for some guidance or interpretation of the specific fact pattern that you're dealing with.
Great advice.
Well, Evan, we hope that our both listeners and viewers have found this as interesting and as informative as both Jeny and I have. Before we let you go, we always take the opportunity during our episodes to get to know our guests a little bit better. So we would like to ask you today to tell us something about you that people don't know if they know you only professionally.
Yeah, it's a good question. I think I'm a bad person to ask this question only because I talk a lot, as the listeners probably know by now. I talk a lot and I don't limit it to professional topics. So I talk a lot about my personal life, the people I work with. So most people know me pretty well. I think an obscure thing would be, and I was actually just talking about this with some summer associates because the summer program just ended, so I'm thinking of that right now. But I'm a big fan of romantic comedies. Like that's like probably my top movie genre. And dating back to, I think it was when I was a summer associate or a very junior attorney, I developed a plot line quasi script for a rom-com. It is legal oriented and it follows the classic formula. One day, if you see a movie called Trust and Love or Love and Trust, I haven't quite decided, on like Netflix or like the Hallmark channel, that would not be me. But anyway, I love rom-coms. It's like, I think if I want to put something on, just zone out, it's top of the list.
Sign me up for that one. So we like to always end our program with a game called The Curious Hat.
And now it's time for the Curious Hat.
And we will pull an imaginary question out of a hat. And today our question is just perhaps bouncing off of the answer to your last question. So let's say, what is the most recent romantic comedy you watched and what'd you think of it?
Oh, okay. The recent, we just watched The Devil Wears Prada 2, which the first one was quasi-romantic comedy. This one wasn't so much. Before that, it was Voicemails for Isabel, I can't remember the exact name of it, but it's on Netflix. It was very good. It was very sweet. The movie itself focuses around I'm not giving away spoilers. It's two sisters, one of which is sick with cancer. It was. I have two daughters, so it was like a little bit more emotional than I would have was expecting it. But it was a very good, sweet movie. And there was a lot of like little references and things for like millennials and folks of my vintage. So I appreciated that.
What? 5 stars.
Well, Evan, thank you so much. Today has been so much fun. We thank all our listeners and viewers. And if you ever do release Love and Trust or Trust and Love, we'll have to update the episode with a link to it in the show notes. Thanks again for joining us, Evan.
Thank you, guys.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.